we definitely have made progress, but it will never be solved. And the progress has taken a long time, and it's basically taken everybody doing everything, everywhere. So that's not a really positive message, but I mean it to be, and everybody in this room and everybody who's spoken to today is representative of, not everybody, but of the many, many pieces of this, terrible problem. Thank you. I'll take questions if there are any, but we have an illustrious panel coming up.
What you might do better to protect the women throughout this process, while also presuming innocent until proven guilty beyond reasonable doubt. How can we do this then? Because the whole thing we heard this morning about the forensic evidence is very intrusive on the woman. Just what can we do to overcome the fact that the woman isn't on trial in court?
Yes, the question of innocence. Frankly, just let me speak about presuming innocence. It's up to the system to presume innocence, frankly. We can't take care of the woman's, this is my opinion, you can't take care of the woman and protect the woman and at the same time sort of protect the victim. The system will take care of the accused, that's the presumption of innocence until proven guilty. That's for the court system, that's for the accused counsel, that's for the judiciary, that's for defense counsel. As far as the protecting the woman from this invasive, not just the forensic process, but the whole process of coming forward, talking about, this act, talking about the circumstances that, brought on the rape, and talking about it again and again, giving information to the police, giving information to the prosecutor, then the woman is still out and about in family and in culture, being asked about it, it's just constant. One of the ways we can protect women is to try to speed up the process, to have a beginning and end that isn't years and years away so she doesn't have to keep living this. But other than that, Jan, I would just say, as much as possible, providing support at every level of this process. Support when she goes for the forensic examination. Support in preparing for her court case. Support in telling her story. Support in being someone outside of the family that she can have contact with and, be in communication with and identify her needs. I just don't know what the better solution is. But I would say that, the standard of innocent until proven guilty, that's built into the system, and I don't think there's any support that we can give a woman that would really impair that, impair the equal justice or impair the justice for the accused. That's on the other side of the ledger. I don't think there's anything you can do for a female who's a victim of sexual violence. You just can't compromise or, worry about the rights of the accused. That's just my hard-nosed position. That's for someone else to do.
But I'm wondering about this whole medical evidence.
I think that's a great point, Jan, and you're catching me out for my saying, you take cases all the way to court that are strong, and that may not be a case that has come to light 2 years later where it may be, but it's a more difficult case when there's no forensic evidence, when time has gone by, when witnesses are not going to talk about it, and when it's the word of the woman against the word of the perpetrator. That's just a more difficult case. It doesn't mean that they all drop off as, according to some checklist, but it is definitely a more difficult case because you have two kinds of things that you have to rely on in court. One is the clinical kind of the circumstantial evidence the, word against word, hopefully with other witnesses, hopefully with someone to support the woman. Sometimes it's even that when you find a person that the woman talked to immediately afterward, if there is such a person, that's good corroboration, because the presumption is, who would make up a story, and I realize it can be abused, but who would make up a story about a rape, because it is shameful and embarrassing. This is the way we perceive it. So, that's some corroboration. If you can find someone that this woman went and talked to right away, even if the person later recants and says, no, she didn't say that. But particularly if the person says, I don't know what happened, I wasn't there, but I know she came to me in tears with, her chemise ripped. I know that, she didn't sleep for the next 3 weeks. I know that she was depressed for 4 months. This is good evidence. It is, credible evidence apart from the medical evidence. But if there is an opportunity to get medical evidence, for me as a lawyer, looking at the chances of getting conviction, I would not discourage a woman. I would encourage and support her in going for the forensic examination, because it's evidence, and supporting her in going through that process is one of the things we can, and in my view as a lawyer now, we can and should do. But it doesn't mean that cases without a jam shouldn't go ahead and shouldn't be evaluated. Those are not, dead cases or cases that, there's just no sense in taking to trial. Thank you very much.
The Human Rights Law Network, Doma Bhutia, advocate, HRLN Sikkim, Monica, HRLN Delhi, and advocate Neha Raj from DCW. The realities of the court, like how we face difficulties, how as lawyers we face difficulties in the court, in the trial process, the appeal process. We'll be also sharing some of our cases. So I wish you guys come to the start.
Good evening, everybody. I'm legal. Do much of the legal work, so I think I'll leave more time for them. I just want to make a few comments about the practicalities of the legal system and about the difficulties of the road ahead. We are very, very far away from real change in this country. We saw the agitation in Delhi, we saw the Verma Committee Report, we saw the tremendous outpouring of anger, and we saw very constructive steps being taken. Even though I am a lawyer, I have a very healthy disregard of the law and a very pessimistic view of the importance of legal proceedings sometimes. But yet I could see that we had made strides in forcing a bill, inadequate though it may be, in forcing a bill on government and keeping the pressure on government for further changes in the law. But as the agitation was going on, I was in Haryana doing cases of gang rape victims in the state of Haryana. And you won't believe it that between the period September 2012 to January 2013, there were 18 gang rape cases in the state of Haryana alone. These are 18 documented cases. And when I met the victims, it was unbelievable. The girls who were 11 and 12 and who were in school were the victims of gang rape. And there's a new fashion, which is that the gang rape is now filmed on the mobiles and uploaded on the internet. So these 16 or 17 cases came and they follow a typical pattern. And I don't want to repeat what is obvious, so I'll quickly tell you what it is. It is after the gang rape, inevitably the case will come to an end. It may take about 6 months to a year or year and a half. But the police and the entire dominant community, these are caste rape cases. So the dominant community will make it so difficult for the family to survive in the village that ultimately the cases are withdrawn. And in one of the cases, where the accused persons told the little girl, a 12-year-old girl, that you have to come back every month. And when she didn't come back, they picked up her mother and killed her mother. Delhi is not India at all. And the changes that take place in Delhi are not the changes taking place in this country, notwithstanding the enormous steps that we have taken in the enactment of this bill. And the change in mindset, I think, of some judges who will take these cases more seriously than they have taken in the past and punish people more severely. But the country will be very slow to change. And I did this case of Bihar. Again, a juvenile studying in school who was gang raped and videotaped. And it was up on the net almost instantaneously. And I'm sorry to say the High Court took a very lenient view of the whole matter, and later on some other developments took place, which were very distressing. There are two things I want to stress today as far as the practicalities of the legal system are concerned. One is this thing about the fast track court, which is like a sort of a magic mantra, so to speak, and everybody says we should have fast track courts, which is perfectly correct. We ought to have fast track courts, I agree. But you must understand one thing. India has 1/5 the number of judges that it ought to have. And the delay in the system is caused by the fact that we need to expand our judiciary 5 times. Can you imagine? And as we were speaking of fast track courts, and in Delhi, I think the Honorable Chief Justice went and actually inaugurated a fast track court after the incident took place. I wrote an article in the Hindu pointing out that as we were inaugurating that one fast track court, there was something like 1,500 fast track courts in the country that were closed down. So now what's happening is a sort of a pretense, a sort of a camouflage, where justice is institutionally impossible. Can you imagine if you have 1/5 the number of judges, you're never going to get justice in this country. I don't think they will fast track rape cases in this country. Maybe Delhi will have that for some period of time. But in the rest of the country, rape cases will take its usual time. And we must have a wider understanding, a more political understanding of what is happening. Why is it that the Prime Minister and his cabinet colleagues are not giving you judges? Why is it that in the family court, apart from rape, matrimonial cases are taking what? 7, 8, 9, 10 years. Custody, maintenance, divorce, taking 8, 9, 10 years. And you fast track rape cases. What happens to the Dalit cases? What happens to the land displacement cases? Because they take judges away from the existing system into a system for rape victims. I'm in support of it. I don't say that it ought not to be there. But I think we must understand the large institutional implications